welcome to the Law Lab. Here, we dissect and unpack everything legal. My name is Jacqueline Opoku, and today we will continue our journey in terms of a contract by considering the aspect of ascertainment of a contract by going further to consider the doctrine of non est factum. This will be displayed on your screen in order for you to know what I'm talking about. When we speak of non est factum or the doctrine of non est factum, it simply means that, yes, you see my signature on this agreement or deed, but it is not my agreement. What does this mean? It means that I have signed a contract, but this contract that I have signed, the signature belonging to me, still this contract is not mine because of various reasons. We have spoken about written contract. Once a contract has been put down into writing, we looked at the fact that it is necessary for the parties to sign the contract. And once their signatures are on the contract, it means that they are ready and they are bound by the contract whenever it is enforced against them. Or even if it is not enforced against them and they decide to perform the contract, it means so far as their signatures are found on the contract, they are ready to be bound by the written contract. Then, where does this doctrine or the defense of non est factum comes from? There are situations where parties will enter into a contract, and although they have signed the contract, they would state or they would tell the court when the contract are being enforced against them that, yes, this is my contract, but this contract does not belong to me. And I have already stated that once a person who is of full capacity and is of sound mind, who can read and understand the contract, or even if he or she is an illiterate person, so far as the contract has been read and explained over to him or her, that means that they understand the contract because the contract was explained and there is an attestation of a jurat attached to the contract. They are ready to be bound by this contract since their signature or their thumbprint or their initials are identified on the contract. In the case of Lienstrace versus Gracu, the court stated that once your signature or once your initials or thumbprint are found on an agreement or a written contract, it means that you are ready and to be bound by the contract. And if you do not perform your part of the contract, the other party who seeks to enforce this contract against you can enforce the contract against you and will be entitled to remedies or damages. We have spoken about written contract, signed contract, or illiterate and written contract. Today, we are focusing on the doctrine of non est factum. As I've already stated, it can be a doctrine or it can be a defense. A defense in the sense that once a contract has your signature appended on that contract, it means that no matter what, so far as you understood the contract and you signed the contract, that means you are ready or you decided to be bound by the contract. But then, it's not in all situations that once a person's signature is seen on a contract, it means that him or her was ready to be bound by the contract. This is because there are situations like vitiating factors, including fraud or misrepresentation or mistake, where a party would sign the contract intending that I intend on signing this contract in order to be bound by this contract because I want to enter into this contract for this specific reason. But then, once they have appended their signature on that contract, when they go over to read the contract, they will realize that no, this is not the contract I intended on signing because it is different, or the terms of the contract are different from what I thought they were going to be. For example, Akosia and Mansa decide to enter into a contract. Akosia, knowing very well that she is intending on signing the contract or agreeing to the terms of the contract because she wants to purchase a blue car from Mansa. But Mansa will make Akosia sign the contract and go back and rectify the contract or edit the contract and write a green car in the contract and decide that I have written a green car, I have Akosia's signature on it, therefore no matter what, Akosia will be bound by this contract. When Akosia reads the contract later on, or a copy of the contract is delivered to Akosia, and Akosia sees that she is purchasing a green car instead of a red car, Akosia will tell the court that yes, my signature is on this contract, but then when we're negotiating or our oral agreement, I told her specifically that I wanted to buy a red car and not a green car. Meaning, Mansa has misrepresented the facts or the terms of the contract to Akosia, and this misrepresentation induced Akosia to sign the contract. Or with regards to illiterate persons, Akosia, who is an illiterate person, will decide that she's entering into a contract with Mansa, believing that Mansa is a good person and Mansa would read the contract to her and explain it. Yes, Mansa will read the contract or the written contract to Akosia, but then whatever is in the written contract, that's not what Mansa is going to read to Akosia. She's going to read a contract that she knows that Akosia will be ready to sign her signature on that contract. When Akosia is taken to court so that the contract will be enforced against Akosia can plead that she's an illiterate person. Mansa will then come in to tell the court that yes, she is an illiterate person, and knowing this, I explained or I read over the contract to her. That is why she signed. With this, Akosia would have a defense of non ex factum. She will say to the court that she read the contract to me. I understood the contract that I am entering into a contract to purchase a red car, but then right now she has brought a green car to me that my signature is on the contract, and so I have to purchase the green car. With this, the court would agree or the court will side with Akosia because Mansa decided to misrepresent the contract to Akosia in order to induce Akosia to sign her signature. Or for example, there could be fraud in relation to the fact that Mansa will tell Akosia that this contract or this car belongs to me. Therefore, sign the contract and let me give the car to you. Later on, Akosia will be driving in this car and someone will stop her that this car is not yours. Meaning, Mansa frauded or made a representation to Akosia that this car belongs to me. Hence, enter into the contract, sign the contract, and let's go ahead and then I'll give you the car. When this is brought up, Akosia will state that yes, I signed these contracts or these written agreements, I signed them, but then it was based on fraud or fraudulent activities of Mansa which caused me to sign this contract. In this situation, the court would agree with Akosia and allow her to plead the defense of non ex factum, meaning this agreement or this deed is not my deed, despite the fact that my signature or my initials are found on this contract. In the case of Lewis versus Clay, the court held that once a party reads and understands a contract and signs his or her signature on the contract, they are bound by the contract. But where the contract or his signature was procured or secured through misrepresentation or fraud, and the party who is seeking the doctrine or the defense of non ex factum can show the court that they were not negligent or careless because they read the contract or the contract was read to them and they fully understood it. But the fact that the contract is based on fraud, they would be entitled to plead the doctrine of non ex factum. What does this doctrine have, or what is the effect of this doctrine? The effect of this doctrine is that the other party or the innocent party whose signature was secured or procured through fraud will not be bound by the contract, or even the court will go ahead to say that this whole contract was based on fraud or misrepresentation. Hence, we are making this contract void or null. When a contract is deemed to be void or null, that means it is not in existence. Although you see the contract, so far as the court has pronounced their judgment that this contract is a void contract, that means the contract will no longer be in existence. Physically, it will be in existence, but legally, it will not be. That means the parties will not be bound by the contract anymore. There are exceptions to this doctrine of non ex factum. The exception is that If the party who is seeking to plead the defense of non ex factum cannot prove to the court or cannot satisfy the court that his or her signature was secured through fraud or his or her signature was secured through misrepresentation of the content of the agreement, then the party will be made to be bound by the contract. Or if they are unable to show the court that although I read and understood the contract, the later contract that was brought to me differs from the contract that I had in mind. Meaning, the contract that I intended to sign is way different from the contract that you see my signature on. Hence, I'm not bound by this contract because of the doctrine or the defense of non ex factum. Another exception is that if the party is unable to show the court that they were not careless or that they were not negligent in appending their signature on the written contract, then the court will state that yes, you are pleading the doctrine of non ex factum, but the negligence of your action or the carelessness of your action of not reading the contract or asking the parties to read the contract for you to understand, you will be bound by this contract irrespective of the fact that your signature was procured through fraud. I have stated the general rule that once a party's signature is seen on a written contract, that means the party is bound by the contract, but the party would be entitled to plead the defense of non ex factum when he or she can prove to the court that although this is a contract that you see my signature on, this contract that you see my signature on, it was secure, my signature was secured or procured through fraud. Or that I was not careless when I was signing my signature, meaning I read the contract and I appended my signature on, but the contract was way different from what I expected or what I intended to enter into. In the case of Gailey versus Lee, it will be displayed on the screen for you to know the spellings. In this case, the court stated that if a party is careless or is negligent in relation to the fact that he or she did not read the contract and went ahead to sign the contract, the party would not be allowed to plead the doctrine or the defense of non ex factum. In this case, in the case of Gali versus Lee, a 78-year-old man entered into a contract and signed the contract. He or she was a literate person but could not see very well during the night. Instead of him to use his glasses, he went ahead to state that, oh, there is no need for me to use my glasses or to wear my glasses in order to see this contract and read and sign. He went ahead to sign the contract without reading it. And later it was found out that it was based on fraud through which his signature was secured. But the defendant party was able to show the court that although his signature was secured through fraud, the other party or the plaintiff was negligent. Negligent here in the sense that instead of him to wear the spectacles in order to read the contract and understand it, he did not wear the spectacles, which made his disability of not seeing very well a negligent act on his part, of which the contract will be bound on him. And therefore, he is not entitled to plead the defense of non ex factum. So far, in our journey of terms of a contract, we have discussed the definition, classification of terms of a contract. We've gone ahead to look at ascertainment of terms of a contract. We've considered written contract. We've considered signed contract. We've considered illiterate persons and written contract. Today, our focus was on the doctrine or the defense of non ex factum, which is a defense that this deed is not my deed. Although you see my signature on this deed, it is not mine because there were fraudulent activities. I was not negligent or careless, or what I intended to sign is different from what I signed. Thank you for joining us on our discussion on the doctrine of non ex factum. Once again, my name remains Jacqueline Opoku, and I urge you to comment, like, and subscribe to the Law Lab channel and share to your friends for them to engage in this fruitful discussion. Thank you.